All right, good morning, everybody. We'll go ahead and get started now. Today is March 15th, 2021, and this is our Law and Policy Committee meeting. Ms. Lincoln, would you please call the roll?
Commissioner Cardenas?
I am here. Good morning.
Good morning, Commissioner Cardenas.
Chair Matt.
Good morning, Mr. Chair.
Here. All right, we'll go ahead and begin then with item number 1. This is public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll proceed to item number 2, approval of our February 3rd, 2021 committee meeting minutes. Commissioner Cardenas, did you have any edits or comments to the meeting minutes?
I do not, Mr. Chair. I'm prepared to move.
All right. Motion by Commissioner Cardenas. I'll second that. Ms. Linker?
Commissioner Cardenas?
Yes.
Chair Matich?
Yes.
The motion passes.
Great. And so for this morning, and I know we're under a abbreviated timeline, we're going to take, if it's okay with you, Commissioner Cardenas, let's take item number 5. Those are our regulations that'll be presented to the Commission relatively soon, and then proceed to the legislative update, since that's time sensitive. And then if we have any additional time, we can go from there. But all right, item number 5. This is discussion of proposed adoption of regulations 18952, 18953, and 18954, municipal campaign expenditures. And we have Erica Boyd, our Senior Commission Counsel, and Karen Harrison, Senior Commission Counsel. Good morning, Ms. Boyd.
Morning. Thank you for having us. So up for pre-notice of this week's commission meeting and presenting to the Law and Policy Committee here, we are looking at regulations to help further define political, legislative, and governmental purpose. Moving back just a bit to give you some historical background on this, these are what's referred to commonly as the personal use provisions of the Act, and it governs what can be done with campaign funds. So in 1990, these provisions were in the Elections Code. They were previously advised upon by the Attorney General's office, and then they were moved over to the Government Code, which the FPPC took charge of interpreting them from there on out. And so at the time they were moved, really what the focus of this is that campaign funds are held in trust. They are not the personal funds of a candidate to use. They're not the personal funds of a committee with somebody having oversight of those funds to use. And so these provisions are really set up to make sure that the funds aren't being misused. To those ends, it defines that an expenditure has to at base be reasonably related to a political, legislative, or governmental purpose, while if it provides a substantial personal benefit, which would be a benefit of $200 or more to the person overseeing the expenditure, it must be directly related to the to a political, legislative, or governmental purpose. Unfortunately, the terms directly related and reasonably related were never really expounded further upon. There are some definitions of political throughout the Act, and then there are also references to political, legislative, and governmental purposes throughout the Act. So as sometimes happens when new laws are put into effect, you get a lot of letters right at the beginning asking about interpretation. There are a lot of letters throughout the early 90s asking about permissible use of campaign funds. Some of those letters, interestingly enough, reference that the commission would be coming up with regulations to further clarify these statute provisions, but that, as we know, did not quite happen. So here we are. Really what we're looking at is trying to provide more guidance to the regulated community and also for our internal enforcement division and legal division in advising on these aspects of what is permissible to use for your campaign funds. So we have kind of a body of law. We've come up with formal advice letters over the year, as well as informal advice. And really what we were tasked with doing was looking through these to see if we could find any common threads to provide further guidance to folks. I will say we've already gotten some feedback from enforcement on, some clarifications or tweaks they would like to see, and we are interested in knowing both from the commission and from members of the public, candidates committees, those doing this day in and day out, if they have recommendations on the draft language as well.
All right, thank you, Ms. Boyd. Commissioner Cardenas, did you have any questions for Ms. Boyd? Commissioner Cardenas, I think you're still muted. I can't hear you.
Quite right. Sorry. Procedurally, where are we? What happens after today, Ms. Boyd?
So this is being brought to you all first. It is slated for pre-notice at the commission meeting on Thursday. And then after that, depending on how the commission feels, if you'd like to have us go further on this, we'll take steps to do proactive outreach to those that this affects, including community partner groups, and then bring it back at a later date with final drafts for the commission to review.
What might be the timing, particularly with respect to outreach to affected stakeholders?
Outreach can begin immediately. We will have this sent out to those on the mailing list to get updates for the interested person type meetings. Here's a small plug here. If you want to join any of the mailing lists currently set up for the FPPC, go ahead and Google FPPC mailing lists and you can sign up for whichever one would be most useful to you. So hopefully this will go out to those who would be mainly affected by any regulations going into effect. And then we're also going to do some personal outreach to key stakeholder groups. After the pre-notice, it would come back. I believe it's slated for 2 months later for final, but that can always be moved or amended based on if we have a lot of feedback and we need to work on it more.
Yeah, this is an amazingly important analysis and review and introspection that will move forward. It's going to be a big year in this particular area. Best of luck to you, Ms. Boyd, moving forward. This looks like terrific work so far already.
Thank you, appreciate it.
So I had a couple questions for you, Ms. Boyd. The first one, just to help us kind of understand historically the distinctions between reasonably related and when there has to be the heightened standard of directly related. So under political purposes, I'm on page 3 of your memo. Third bullet point,
yes.
It's the Downing advice letter. Mm-hmm. And there, the yes. description says that the commission determined that there was directly related to the political purposes. And this was campaign funds for a celebration of life event for a political activist. Why was that letter analyzed under the directly related standard rather than the reasonably related standard?
Thank you. And I've actually split up these letters with my wonderful co-counsel showing up here, Karen Harrison. So she is going to address the Downing letter.
All right. Good morning, Ms. Harrison.
Good morning. So the Downing advice letter is an interesting advice letter because it involved a celebration of life event. And we had previously done a letter where there was a memorial service that was found to not be related to a political purpose. And there was a personal benefit because the family wanted to use campaign funds to pay for the funeral service, basically. And so this letter is kind of the next step in that analysis where there was a celebration of life in a political, for a political operative that had passed away. And so your question is, why was the standard directly related rather than reasonably related?
Right, because when I look at I'm looking at footnote number 2, the definition of direct personal benefit, which I think triggers that heightened scrutiny as I understand the current standard. I don't see how that definition in footnote 2, and that's in regulation 18960, would be applicable where, at least on this description, the committee paid for a celebration of life event for a political activist, not for based on that description, I'm assuming that is not the candidate themselves, right? So that's my question, is how come would be considered direct personal benefit to the committee?
Sure. So I think that the reason why it fell under that standard is the inherently personal nature of a memorial type service. And I think your question is a good one. These are the kinds of questions we get into. Should the standard be directly related? Should the standard be reasonably related? And I think the concern was, did this somehow, was this of such a personal nature that it shouldn't be a campaign expenditure? But I think you raise a good point. Questions of which standard should be applied come up in these letters, and they're fine points. But I think that had we not had the previous letter where memorial service was seen as so inherently personal that it's something that the family should have borne, that question comes up. But if you're looking at it from the context of the different organizations that were a part of this letter, there were several different types of committees. I think the question would be, is this more of a gift when you're holding a very personal memorial service? But in this context, it was a political networking type of an event rather than a family's memorial service.
Okay. All right. Another question for you, and thank you, Ms. Harris. I'll let you and Ms. Boyd decide who wants to field this one. But I'm looking now on page 4, PLG purpose. It's bullet point number 2. The first one is you have a school board member who was attending a Harvard summer program. And then there was the last bullet point where a candidate could not use the funds to attend a master's program. And so I'm just curious, for the benefit of the public, under our existing rules, why were those outcomes different?
Yep, I'll take this one. So on the Harvard one, got it. It was a 3-week summer program where the school board member was specific. It was a program designed for high-level officials and local government officials that were trying to improve both their public policy analysis skills, their communication skills, other things that dovetailed directly with the person's duties as an elected office holder. Again, it was a 3-week program. It was during the summer, and we had opined in that letter that it was permissible to use funds both for travel and the tuition for that program because it was going to be directly related to the person's role in performing their school board duties. With the one where the candidate wanted to use the funds for the master's program at Stanford, I think that, first of all, it was a different temporal time frame. We're looking at a 1 to 2 year program, and it was going to be looking at international issues, which he said were important to the constituents in his community. It was also something that was going to actually, confer a degree on him at the end of the program, that the analysis at the time said that that was more of a benefit to him personally, as opposed to him carrying out his duties as an elected official. So I think in those, we were looking both at the temporal time frame and really who the benefit was going to go to in the end. If you're getting a 2 years master's program, that's not helping you in your day-to-day carrying out of your duties of your supervisor at the time.
Thank you. I appreciate that explanation. Last question, I think. I'm looking now at the proposed regulations. It starts on page 4, but the meat of it's on page 5. And this is definition of political purpose. And it's the second paragraph where we talk about how staff is currently thinking we may want to define this. And you use the phrases ordinary and necessary to further identified primary political objective of the committee would not occur absent the identified primary political objective of the committee, et cetera. And so, and this is the important part, and does not offset regular personal expenses of a member of the committee. So my question for you is, I remember last year or the year prior, the commission supported legislation, which I believe now permits the use of campaign funds for certain childcare expenses for candidates. How does that square with the language here?
It squares here in terms of, how that provision is set up is that you wouldn't have the childcare costs, but for participating in the campaign activities that the candidate is doing at the time, or political or legislative, governmental or legislative activities of the office holder. So I think it does square with this. But in addition to that, we can also put in specific language to these regulations that anything already permitted by statute and obviously gone over by the legislature and approved would not be subject to further interpretation by these regulations.
Okay, all right. All right, Commissioner Cardenas, any additional questions from you on the proposed regs?
I just want to suggest that that was a very clever response, Ms. Boyd, and I don't mean to to disparage that. If that was prepared, well done. If that was on the fly, that's really impressive. But the point I wanted to make is, it seems to me that as soon as I heard Erica say "but for," it seems to me that your classic first year law school but for analysis is probably rightfully invocable in a lot of these types of analysis, but for the exigencies and the specific nature and obligations of the office holder would not, or at least it's reasonably expected they would not be incurring this kind of an expense. And that's not necessarily dispositive, but it could illuminate the relationship between the expenditure by the committee as being reasonably related to a legitimate purpose. That's all I wanted to suggest. Well done.
Thank you.
Chair, this is Karen Harrison. I was wondering if I could just make a follow-up comment. I don't feel that I answered your earlier question about the Downing letter very well, and just reviewing it quickly. In that situation, the event that they were hosting was seen as a gift to the attendees, and personal gifts are limited under the statute 89513F. And if you're making a personal gift, it needs to be directly related to a political or legislative or governmental purpose. And that's why you get that directly related standard. I was more focused on the funeral aspect when you were asking the question, so I didn't want to miss that.
Okay. Well, that is helpful, Ms. Harrison, actually, that clarification, because I think that highlights that the political, legislative, governmental terms that we're seeking to define here, I think initially it was framed as this is important for determining what's a permissible campaign expenditure, for example. But I think, to your point, this also crosses over to when something is a gift and implicates that body of law. And then I was actually going to ask you, doesn't this not also then implicate behested payments? Because aren't legislative and governmental purposes part of the behested payment analysis as well?
That's correct.
So these standards and new definitions that we're considering for our regulations, they're pretty sweeping in scope then, aren't they? It's not just campaign funds, it's behested payments, and it's gifts.
I think that's a very important point, and good to look at it this way. The way the regulations are drafted, they're limited to the campaign use provisions. They're limited to this particular part of the act, but it's going to color how we're interpreting legislative and governmental for the act, of course. So that's something to consider. But right now, the way the regulations are drafted, they're limited to interpreting these provisions in the act.
Do we currently have a uniform set of definitions that we apply across the three areas I just articulated for legislative, governmental, et cetera?
Well, political purpose is defined in the Act, in the definition of expenditure, and legislative and governmental have not been defined in the Act and have not been defined in regulation. That said, these guidances are not terribly controversial as far as what is governmental, what is legislative. And in this context, this is the guidance that advice letters have given.
Let me ask it differently then. Today, this is being presented to us as defining terms that are relevant to campaign expenditures. But the terms legislative and governmental expenditures are also, or purposes, excuse me, are also relevant to behested payments and gifts. Would we ever define those differently for behested payments and gifts? Or should we assume that the work we're doing here today under the heading of what we're doing for campaign expenditures is also necessarily going to apply to those areas as well?
I think that that's something that if there were distinctions between, say, a legislative purpose for a behested payment as opposed to a legislative purpose for campaign expenditures, that could be noted in regulations. I think the start of defining a legislative purpose, a lawmaking purpose, is limited right now to this body of law for a reason, so that it doesn't have those broader implications. So we have areas where we make distinctions in regulations that this only applies to this category. I'm not anticipating conflicts or issues, but fine points may arise. And usually how we deal with those fine points or something that doesn't quite work in another part of the Act is that we limit its application. So okay. I think we're exploring that right now.
Okay.
I think to add to that as well, this will definitely color, I believe, how we look at those other areas of the law as well, given that we need kind of a framework that's the same across the board. And so I know that Karen's working on behested payments for later this year too, in terms of the regulatory calendar. So I think our hope would be that there would be a consistent definition across the Act where those terms are used, both again, for practitioners to be able to know how it's going to be interpreted by our agency, and internally for legal and enforcement to be enforcing it all and say, or applying it all in the same way as well. So there is consistency to those terms.
All right. Can I ask if that's what we anticipate? Then wouldn't we want to place these terms in the either like sort of the general definitions portion of our regulations so that it's clear they have broader application than just the context in which they've been presented? I mean, if that's what we're going to do, wouldn't that make more sense? Is really my question.
Mm-hmm. I think that's the directive from the commission. We're happy to take a look. Yeah.
All right. All right, Commissioner Cardenas, anything further from you on these regs?
I just want to suggest you're going to have a lot of fun with us this year. Mr. Chair, I hope I get to enjoy the get to enjoy the frivolity for as long as I can. But this is incredibly important. Just as soon as you suggest that these are as definitional matters, these could and perhaps should apply across the board. This is deep. You know how many angels can dance on the head of a pin? Yeah. You've got your formula. I might have mine. Ms. Boyd, Ms. Harrison, a good work and good luck.
Thank you.
I agree. I think you guys have done great work. I think it's a great place to start, and look forward to continuing the discussion with you and our colleagues. All right, if there's nothing further, well, thanks. Do we have a public comment on item number 5 before we move on? Hearing and seeing none. Thank you, Ms. Boyd. Thank you, Ms. Harrison. We'll go ahead and move to item number 3 then, our legislative update, and we will welcome our legislative counsel, Ms. Nakano. Good morning.
Good morning. So I know we have an abbreviated schedule today, so I'll try to be quick. I have some good news about several commission proposals. AB 236 was amended with the commission's preferred language and approach on LLC disclosure. Previously, the bill amended the definition of multi-purpose organization to include LLCs. So now both AB 236 by Assemblymember Berman and SB 686 by Senator Glazer contain the commission's LLC proposal, which, as you remember, would require LLCs to qualify as a committee or committee sponsor to file a statement of members with the Secretary of State. So we don't know yet how the two bills will be reconciled. That will come out in the legislative process. But for now, I think it's a good position to be in that we have both chairs of the elections committees on board with our proposal. Also, more good news, AB 1367 by Assemblymember Lowe was amended last week and now includes 2 commission proposals. The proposal that would extend the one bank account rule by requiring recipient committees to maintain a single bank account for all contributions and expenditures, and the proposal that would increase penalties for egregious personal use of campaign funds. AB 378 by Assemblymember Bauer-Cahan removes gendered language from certain areas of the government code. I previously reported that the Assemblymember agreed to include PRA sections in the bill, and the bill was officially amended last week to that effect. Staff is working with the Assembly Elections Committee on a committee bill that would include the commission proposal to transfer the duty to collect the penalty for failure to pay the annual committee fee to the Secretary of State's office. That bill is not certain yet, but I will keep the commission posted on any updates. So those are the updates I have on the commission-sponsored proposals. Due to our abbreviated schedule today, I'll hold my full report on other commission-related bills until this Thursday at the full commission meeting.
Thank you, Ms. Nakano. Commissioner Cardenas, any questions for Ms. Nakano?
No, I just want to suggest for a brief report. There's a lot of good news here. My takeaway, Mr. Chair, is that after a COVID hiatus, unfortunately, from non-COVID related legislative action over the last year, it certainly seems in the last few weeks, Mr. Chair, that our voice through Ms. Nakano is certainly being held by the proprietors of these various bills, and I think that bodes well for our influence and for our ability to work in partnership with our elected officials to make sure that the people's concerns are met. I also, Mr. Chair, want to take a personal privilege of apologizing to you and to our staff and to the public. It is my fault that the committee needs to have an abbreviated session today, or at least I will need to beg off in a few minutes. This is my own personal inability to effectively manage my time. The evidence today for which I am profoundly regretful. My apologies, Mr. Chair, and thank you, Ms. Nakano, very much.
Don't worry about it, Commissioner Cardenas. We're gonna see you Thursday. Maybe we'll have a longer meeting on Thursday to make up for it. How's that sound?
Thursday. What's... Oh yeah, right. Of course.
Don't forget.
Oh yeah, man. Yeah, I'm all over that.
Yeah. All right. Well, let me just echo your comments. Our legislative priorities this year seem to be moving along at a very good pace. And I just want to say I think that's directly attributable to Ms. Nakano and her efforts. She's doing a great job for us and is coming up to speed very quickly. I mean, it shouldn't be lost that it hasn't even been a year that you've been with us. So great job, Ms. Nakano. Appreciate your efforts. So with that, well, let me call for, is there any public comment on item 3? All right, hearing and seeing none. At this point, I would hold item number 4. This was an informational item on advice we provided regarding local contribution limits. That is something that I understand will be presented to the full commission soon anyway, and so we can hold that presentation for the full commission, so no harm there. And item number 6, we can discuss at the commission meeting later this week. So with that, I would move to adjourn at this point. Commissioner Cardenas, do I have a second from you?
With my appreciation for everyone's indulgence today, yes, I will second. Thank you, Mr. Chair. Thank
you, sir. Ms. Blanker?
Commissioner Cardenas?
Yes.
Chair Match?
Yes.
The motion passes.
Great. Thank you very much. We'll see you Thursday.
Yes, of course.